interchange appeals.
Yes, Mr. Turner.
May it please the Court, I've got two fairly short points remaining to cover on ground one. I'll then turn directly to ground two, which Mr. Hoskins and Miss Rose addressed you on yesterday. I aim to conclude by 12:20. My first task is to bring to a conclusion then the submissions I made on the alleged Korean error by the Court of Appeal. Here, Visa's proposition is that the Court of Appeal overrode factual findings and assessments which had been made by Mr. Justice Phillips in favour of findings and assessments that had been made by the European Commission. In contrast, MasterCard's proposition is that the Court of Appeal erred by accepting the factual findings and assessments by Mr. Justice Popplewell, because Mr. Justice Popplewell reached his findings and assessment despite, they say, there being unchallenged evidence. In both cases, the schemes treat the conclusion that there was a restriction of competition for the purposes of Article 101, first paragraph, as itself a pure factual finding or assessment. So far as that goes, I have essentially outlined my position yesterday. As you see from the General Court judgment, in particular paragraph 143, which was endorsed by the higher court at paragraph 195, if a court is confronted with certain facts, it necessarily follows, to use the General Court's wording, that there is an agreement which has effects restrictive of competition. Those facts include, 1, the operation by a payment card scheme such as MasterCard's of a multilateral interchange fee rule. 2, the effect of that rule in setting a minimum reservation price or floor for the prices which are charged by individual banks to their merchant customers. And 3, the absence of MIFs would result in a payment system like MasterCard's and Visa's continuing to function with no interchange fees, in other words, settlement at par. In the present cases, the Court of Appeal recorded that the two commercial court judges arrived at their own findings on those matters of fact, which were in line with the findings of the European Commission in the European case. And if you would please take Core Volume 2 and have the Court of Appeal judgment in front of you, they do that at paragraph 133 on page 5237 at letter D. This is a heading, the significance of the Commission's decision, and halfway down at D you'll see that they say the Commission's conclusion was broadly the same as that agreed before both Mr. Justice Popplewell and Phillips, namely that in the counterfactual situation, in the absence of a challenged restriction, issuers and acquirers would ultimately not agree bilateral interchange fees, so that the situation would revert to settlement at par, with negotiations between merchants and acquirers being undertaken as to the service charge absent the MIFs. That then led straight to the key paragraph in the Court of Appeal judgment that I took you to yesterday. If you turn the page, paragraph 146 on page 5239 at the foot of the page. Essentially, the reasoning to be applied to those facts is a legal conclusion based on the factual premises stated. Now, on a correct analysis, to stand back, there is no sense in which the Court of Appeal overrode factual findings, relevant factual findings, by Mr. Justice Phillips. To start with him. First, they did not override the factual finding of Mr. Justice Phillips on the evidence that there would be no new process of competition through the striking of bilateral interchange fees if MIFs were removed. And you may recall, I don't need to go back to it, I think, that Mr. Justice Phillips refers to and relies on that finding that he made on the evidence at paragraph 160 of his judgment, page 5797 in this bundle. Second, the Court of Appeal also did not contradict a factual finding by the trial judge on the evidence he heard that the degree of competition between acquirers in respect of the acquirer's margin, part of the charge, the icing on the cake, is just as lively with a myth as without one. In truth, he doesn't appear explicitly to have made any such finding of fact in his judgment at all when you read it through. Rather, the position is simply that the Court of Appeal has pointed out that based on the authority of the European courts, Mr. Justice Phillips misunderstood how to apply the concept of restriction of competition. He erroneously accepted Visa's argument that the collective act of raising prices to the merchants wasn't pertinent to the issue of restriction of competition when he shouldn't have done. What the Court of Appeal then did was apply the law, as stated by the European courts, to assess whether the concept of restriction of competition applied to the facts which the trial judges had found. Finally, then, that takes me to MasterCard's position. Their contention is that Mr. Justice Popplewell reached a finding on the evidence which wasn't open to him because MasterCard's expert evidence on restriction of competition stood unchallenged. And I had described this yesterday as my fifth and final point under ground one. In their notice of appeal, they argue that Mr. Justice Popplewell reached his assessment that there was a restriction of competition without having any proper factual basis, because they say their expert evidence was unchallenged, and that is to be found in footnote 4 of their notice of appeal at page 4680, to which I don't need to turn. The argument is incorrect. Our expert economist, Mr. Dryden, gave the court his opinion that the process of competition in the acquiring market was restricted because of these myths. And Mr. Justice Popplewell accepted that evidence. I invite the court to look at the argument in MasterCard's written case, which you will find in Core Volume 1 at tab 7 at page 4940. Tab 7. Paragraph 65, which occupies the majority of the page. What you'll see is that MasterCard sets out an extract from the cross-examination of Mr. Dryden. And you'll see from the judge's question in the middle of that extract.
I'm so sorry, Mr. Stone, I've not got the page, which was the...
I'm sorry, it's 4940.
One. Yeah.
Yes, thank you.
Yes, so this is what they rely upon. There's the extract from the cross-examination, and halfway down, Mr. Justice Popplewell, you're saying it restricts competition because there is a flaw, but it doesn't eliminate competition because this is over the entire amount, because there's still competition in relation to the acquirer's margin, precisely. So that was the evidence that was given, that there was a restriction of competition. It was therefore not unchallenged evidence that there was no such restriction. And in Mr. Justice Popplewell's judgment, at paragraph 161, he dealt in impeccable terms with the submission put to him that Mr. Dryden had actually given evidence that the MIF did not restrict competition in the acquiring market as a whole. And if I may invite you to look at that, we go back to the Core Volume 2 Court of Appeal's judgment at page 5673.
This is
Sorry,
in
not,
Mr.
yes,
Justice
it should be
Popple.
Mr. Justice Popplewell's
Mr. Popplewell's
judgment.
judgment, yeah.
That's right, 5673. Top of the page, thirdly, Mr. Hoskins submitted that the evidence of both experts was that competition in the acquiring market isn't affected by the level of the MIF. That was a mischaracterization of the evidence. Mr. Dryden's evidence was not that there would be no material difference in competition on the acquiring market, merely that the level of the MIF did not affect the ability of acquirers to compete with each other on the acquirer's margin. His evidence was that the MIF did restrict competition by creating a flaw, a restriction which is not removed or mitigated by the ability to compete on the margin. Dr. Niels, that was MasterCard's expert, stated that even if the MIF has the effect of raising the price in the acquiring market, this does not restrict the acquirer's ability to compete on the level of acquiring margin. Acquiring competition would be the same whether the MIF is set at, say, 0 or 1%. And then the judge criticizes the MasterCard expert evidence. This reasoning is fallacious because it conflates competition on the level of the acquiring margin with acquiring competition as a shorthand for competition on the acquiring market. It ignores the restriction on an acquirer from setting an MSC, merchant charge, below the MIF. It's equivalent to saying that a manufacturer's pricing agreement, which inflates the price charged to wholesalers, isn't a restriction of competition on the retail market because wholesalers are free to compete on the margin of profit they charge in the retail price to customers, a proposition whose falsity is self-evident. MasterCard's main written response to this is that even with settlement at par, you've still only ever got competition in relation to the acquirer's margin. They say nothing has changed, but something has changed. There is now competition on an individual basis over the entirety of the price being charged to the merchant. No component of it is predetermined by a collective fee driving up the price to the merchants. Visa and MasterCard have also sought to say, hitherto, that the MIF is only an inoffensive input cost into the acquirer's businesses, like any other. Ms. Rose said on Monday that it is, and I quote, simply a common input to the cost base of all the acquirers. But it's not an input cost akin to, say, the cost of iron for a steel maker or the cost of water for a paper manufacturer. It's a payment, which is the outcome of a collective agreement between MasterCard and the banks. And nor, if I may say so, does the argument that the MIF is legitimate because it's equivalent to the scheme fee, which is paid by the banks to MasterCard or Visa to cover their operating costs, help the schemes, because where prices are charged to customers and are driven up dramatically by reason of the coordinated behaviour of their suppliers, and that affects their incentives, and it's not objectively necessary, this is behaviour which falls within the first paragraph of Article 101. And whether scheme fees are always benign is an open question. Concerns have been raised about these schemes and their banks using the mechanism of scheme fees as disguised equivalents to the MIFs. Finally, I'd note that the analogy which is given by Mr. Justice Popplewell at the end of this paragraph we have just read is attacked by Visa. That is in their written case at paragraph 46. They say there that a manufacturer's pricing agreement restricts competition between the manufacturers only, because in the absence of the agreement, manufacturers would compete on the prices they charge to the wholesalers. According to Visa, the effect on the market downstream, the retail market, where the wholesalers sell, is to be ignored. They are wrong in that contention, As it says on the tin, Article 101 is concerned with prohibiting measures that have the effect of restricting competition, irrespective of the market where that effect is felt. And so in conclusion, for those reasons, MasterCards and Visa's first ground should be dismissed. And I move directly to ground 2. Mr. Hoskins yesterday made 2 basic points. One, that EU law doesn't require that a party who wants to show the benefits from a restrictive agreement outweigh the harm must rely on factual evidence, the type of evidence point. 2, that the standard of proof that a party has to meet to satisfy Article 101, third paragraph, is the ordinary civil standard, balance of probabilities. It's not an enhanced standard. Now, he said that the Court of Appeal went wrong on both of those 2 points, and it infected the entirety of their reasons for overturning Mr. Justice Popplewell's decision on the Article 101, paragraph 3 issues. And I'll take each of these points in turn, and I'll begin with the question of the standard of proof. In my submission, this is really a non-point. The Court of Appeal explicitly said that the standard of proof is a matter of English law, and they said that the usual civil standard of the balance of probabilities applies. If you have their judgment in Core Volume 2, the relevant paragraphs are to be found on pages 5224 and 5225, and those are paragraphs 77 and 81. 77 concludes with the Court of Appeal recognising that the usual civil standard applies. That's between E and F, page 5224. And paragraph 81 refers to the standard of proof being a matter of English law. It says that what informs it is the EU law requirement concerning the type of evidence. So the only issue here on standard of proof is their approval of what Mr. Justice Phillips had said. In a quoted extract from his judgment, you find at the foot of page 5224, starting at letter J, if you have that. Mr. Justice Phillips had said, "I see no difficulty in this court determining whether the former has been proved on the balance of probabilities. The test is capable of accommodating varying requirements as to what's expected to meet the standard. Contract terms must be certain, allegations of fraud must be distinctly proved, and it's often said that cogent evidence is required to rebut certain presumptions. In the case of Article 101.3, it's recognised robust analysis and cogent evidence will be required to establish on the balance of probabilities that a restrictive agreement in fact and in the real world, as opposed to theory, gives rise to pro-competitive effects." So there you have the basis of the proposition that a party who wants to justify a restrictive agreement must bring forward cogent evidence to satisfy the balance of probability standard in our legal context. I'll address that proposition at the level of the general law and the scheme of Article 101, and secondly at the level of the particular problem which is being examined by the courts below, namely these interchange cases. At the level of the general law, the reason why cogent evidence should be needed to meet the civil standard is concisely summarised in the Commission's guidelines, and in any event it is intuitively obvious. You have those guidelines in Authorities Bundle 3 at tab 30, and I'd ask the court please to go to page 1624. Mr. Hoskins read around paragraph 55, but not specifically that paragraph I would direct you to the words at the top of the right-hand column on the page, 3 lines down.
Sorry, the page again, please.
1624, my lord.
Paragraph.
So this is paragraph 55, which starts at the bottom of the left-hand column and goes to the top of the right-hand column. Reading at the top of the right-hand column, from 3 lines down, they record, given that Article, what is now 101.1, only applies in cases where the agreement has likely negative effects on competition and consumers, efficiency claims must be substantiated so that they can be verified. Unsubstantiated claims are rejected. That's the reason why, as a matter of the scheme of this provision, you would expect cogent evidence to be needed. At the level of the particular problem before the court today, interchange fees, there are further clear reasons why cogent evidence should be needed to meet the standard of proof. The first is the point that these schemes and the banks are entering into these MIF rules with a view to boosting their own profits, not to help others. And indeed, the way in which they are setting out to increase their own profits is precisely by combining to charge extra amounts to the merchants. Therefore, if the schemes wish to say that the victim of their restrictive practice, or more neutrally, the target of the restrictive practice, the merchants, are better off, and to say, we are really doing this for your own good, one would naturally expect to see cogent evidence before concluding that their assertion was probably right. It's not obvious that what is good for General Motors is good for America. The second point is that in these cases, the amount of the detriment from these multilaterally agreed charges in the form of the revenues which are extracted by the banks from the merchants is very large. It amounts to many hundreds of millions of pounds. Because these charges make up around 90% of the overall merchant service charge, it means that merchants are paying 10 times the merchant charges that they would otherwise be paying without these. It's right to treat the suggestion that they're part of a group that's really benefiting from this with some skepticism. So if the schemes and the banks are going to show that in fact there are advantages to others, to consumers from this, which outweigh the readily quantifiable detriment, again, it is natural to expect in this particular context that there would be cogent evidence. And third, there is a point which was made by the Commission and by Mr. Justice Popplewell on the basis of the evidence before him that the competition which happens between Visa and MasterCard as payment schemes to attract issuing banks' business for their respective organisations puts upward pressure on interchange fees, an upward spiralling effect, so that they tend to rise for reasons which have nothing to do with benefits to the public. And I'll merely give you the reference, Mr. Justice Popplewell, paragraph 142, subparagraph 2, at page 5666.
Arithmetically, if the myth is 95% of the MSC and
90%.
90%, you said.
90,
right.
yes.
Thank you.
So I turn to the second issue, the type of evidence required. All this boils down to is the proposition that there must be some factual evidence put forward by a party, a foundation of factual evidence, if they are seeking to claim that a restrictive agreement is exempt from the treaty prohibition. The Court of Appeal never said that economic theory evidence was either inadmissible or irrelevant, in addition to factual evidence, as MasterCard suggested. We gave the reference to their written case suggesting that in paragraph 82A of our own response case. The proposition that some factual evidence is needed, as a general rule, flows, as my Lord Reid commented yesterday, from the treaty provision in question. Because Article 101, third paragraph, involves a balancing exercise. The case law on this is perfectly clear. It was first articulated by the European Court in a case long ago in 1966 called Constant and Grundig. And a brief and lucid exposition of what is involved is to be found in the GlaxoSmithKline authority, which you have in the second authorities bundle at tab 19, page 633. This is an authority that Mr. Hoskins took you to yesterday, and the key section for these purposes lies between paragraphs 247 on that page and 250.
Sorry, the page again.
This is page 633 in Authorities Bundle 2, tab 19. You'll see that the heading at the top of the page is evidence of a gain in efficiency. And under that heading, in paragraph 247, the court records general statements of the law concerning the test. They first make the point that the sort of benefits that one is looking for, even under the first condition, don't include the profits of the undertakings involved. They are what's called objective advantages, and they must be of such a kind as to offset the resulting disadvantages for competition. If I may say so, the submission to the contrary that the profits of the schemes could be taken into account at this first stage by Miss Rose at day 1, page 142 of the transcript, was not right. It follows naturally from the need for a balancing exercise, which you see set out in paragraph 247, that there will be a need for some real-world factual evidence. And in line with that, paragraph 248, immediately below, refers to the need to examine the factual arguments and evidence submitted by parties to a restrictive agreement. Mr. Hoskins said orally that this merely reflects the circumstances of this case, that in GlaxoSmithKline there was factual evidence submitted by the parties. But that isn't how paragraphs 247 and 248 are expressed. They set out general principles. And moreover, the same test was articulated by the Court of Justice judgment in the MasterCard judgment itself, which you find in Authorities Bundle 2, the same bundle, tab 25 at the end, at page 1079. If you go there, page 1079 at the end, and you look at paragraph 235, halfway down, the Court of Justice in the MasterCard decision in 2014 refers back to GlaxoSmithKline and makes the same reference to the need for factual arguments and evidence provided by the undertakings. And please recall that yesterday in this context, Mr. Hoskins made a point of telling this court that MasterCard had offered the Commission no empirical evidence in those proceedings. Transcript day 2, page 38. Yet, the Court of Justice nonetheless refers in its statement of principle to a need to assess factual arguments and evidence submitted. Now, Mr. Hoskins referred to a further European case. He said it was authority for the proposition that under European law generally, you apply a principle of unfettered evaluation of evidence. And from that, you can deduce that a case could be mounted to justify restrictive practice in the right circumstances based on pure economic theory. The case he referred to was called Salzgitter, about a steel tubes cartel. It's at Authorities 10, tab 81. I shan't go to it in detail, but I will say this. It is not on point because that was a case where the court said that the administrative agency, the European Commission, did not need to exclude certain evidence from its competition appraisal on the grounds that it was confidential and hadn't been shared with the parties to the investigation. That point tells you nothing about whether it's sufficient to rely on evidence of pure theory in the framework of the four conditions of Article 101, paragraph 3 of the treaty. In the interest of time, I understand that Mr. Khan for the Commission is likely to deal with the other case mentioned, e-Turas, the remaining authority relied on by MasterCard. Now, as with the issue of standard of proof, I now turn from the position under the general law on the type of evidence proposition to the circumstances of our particular cases. Because in our cases about interchange fees, you have particular reasons why you would expect the schemes to lead a foundation of factual evidence with a view to establishing that the advantages to the public from their practices outweigh the very substantial detriment. And the starting point is the Commission decision. There are three main points in this regard that you get from the Commission's landmark infringement decision in 2007, which was upheld on appeals to the European Judicature over the following 7 years. And the principles which emerge from the decision and the appeal judgments remain sound. They have in no way been superseded by the terms of undertakings or these commitment decisions made between the Commission and Visa and MasterCard, which were made to avoid the Commission proceeding with a full competition investigation. There are three headline points before we open it up. Point one is the point that was noted by Lord Reid in the course of Mr. Hoskins' address yesterday. And this is the point that the Commission decision, when you read it, does refer to a general need when you're carrying out a balancing exercise under the first condition of Article 1013 to assess factual real-world evidence about advantages and disadvantages. It says it in terms. Might not be binding, but that is their legal view. The second point is this. In doing this, you have to consider the economics of the card issuing bank's operations, and that is critical in this context. Ms. Rose submitted to this court on Monday as follows, transcript page 41 from line 25. She said, if the issuer is required to settle every transaction at 100% at par, the issuer is going to incur a loss on every transaction because the issuer is incurring costs on those transactions. Now, the Commission and the General Court on Appeal pointed out a fallacy in this, and it was also strongly underlined by Mr. Justice Phillips in his second judgment, and it was referred to by Mr. Justice Popplewell too. And it's the point that the issuing banks gain a range of wider advantages and income flows from issuing credit cards and debit cards being linked to banking current accounts. It is wholly wrong to ignore the impact of those other income flows and advantages when you are asking a question, to what extent does this collectively determined myth cause the issuing banks to continue to maintain or abandon the card services that they're offering? And inextricably connected with that, among other things, is the question of what has been referred to, as you will have seen, issuer pass-through. The money from this multilateral interchange fee charge, some of it sticks in the pockets of the banks, and to the extent that that happens, it cannot be taken into account in the balancing exercise under the first condition. And for that reason, it's essential to consider the factual extent to which you have issuer pass-through also. Once again, that is an issue that both the commercial court judges, Mr. Justice Popplewell and Phillips, appreciated. and which Visa and MasterCard hitherto have both accepted. As you'll see, another facet of this is the justification which MasterCard and Visa both advance for their MIFs, which is that the money is used by the issuing banks in their systems to stimulate further use of cards by the public, the spending public. And in assessing the significance of this, you have to also consider the extent to which the public already is choosing to use payment cards to buy goods and services without the need for an additional stimulus funded by this collective charge. The third point, which you will see in the Commission decision in a moment, is this. The nature of MIFs, as the Commission bluntly said, is that there is no reason in theory to suppose that their operation will be beneficial to consumers overall. They could overburden the merchants who must pay what amounts to a private tax on every card transaction which is made with them. And with that, may I now ask the Court please to open Appendix 1D and turn to the Commission decision, the relevant section beginning on page 7078. So we're now within the section that's begun on the previous page, the large section entitled Article 81.3 of the Treaty. And this is the subsection, first condition, technical or economic progress. And you'll see from paragraph 671 at the foot of page 7078, the last four lines, given that for Article 81.3, now 101.3, to apply, the pro-competitive effects flowing from the agreement must outweigh anti-competitive effects, it's necessary to verify what the link between the agreement and the claimed efficiencies and what the value of these efficiencies are. And then over the page, they set out from the guidelines the relevant elements that need to be considered in that connection, which you have already seen. We go forward from that to page 7082, paragraph 686. And this is on the point from Miss Rosa's submissions that I mentioned a few moments ago. There, you'll see that the Commission is addressing the argument that without this MIF, they don't have the ability to cover their costs of providing services. And the Commission points out that there are wider economic considerations which must be assessed concerning the issuing bank's economics. And from 5 lines down, they say if receipts, interest, money exchange fees, penalty fees, and so on, or other monetary benefits, such as resulting from cost savings, reduction of staff paperwork, etc., from payment card issuing, provide sufficient commercial incentives for the banks to invest in incremental card issuing, a transfer from acquiring to issuing may be superfluous and even counterproductive, as the revenue dampens card acceptance due to the increase of costs on the merchant side. Robust empirical evidence is therefore required to establish the necessity for and the direction of a fallback interchange fee. If you'll note, you'll find a parallel statement made by the Commission a few pages on at paragraph 720 in relation to debit cards in particular. Now, these were referred to in the judgment of the Court of Appeal. I won't go there yet. Paragraph 688 on page 7083, facing page, at the top, that shows the nature of the case that MasterCard was making before the European Commission about why there were benefits from their arrangement. It's essentially, it was that these charges are designed to maximise the use of the scheme's payment cards in society, and that in itself leads to gains for both merchants and cardholders in the ways that they explain there. Below that paragraph, you have 689 and 690. 689 is referring to the ways in which MasterCard was alleging that there were net benefits. And then the following paragraph 689 makes the point that so far as these MIFs are concerned, it cannot just be assumed that customers are better off from such a practice without detailed empirical and economic analysis. They say, the last sentence, that the mechanism may overburden one side of the scheme with artificial costs while not yielding any positive effects on the scheme growth and on overall efficiency. And at 690 you have the conclusion that is drawn, that facts are needed when you're confronted with the task of assessing the pros and cons of a MIF mechanism. Before leaving this page, I'd ask you also to note footnote 834, where they say from the second sentence, as will be shown below, the conclusion that a collectively set MIF will maximise system output, even that proposition, the starting point, follows only under very restrictive assumptions. Likewise, maximising system output cannot be presumed to be consumer welfare maximising, that is, maximising the consumer surplus for cardholders, merchants and subsequent purchasers on theoretical grounds. If you then go forward, please, to 7084 over the page, and look at paragraph 695, this is under a heading, as you'll see, need for empirical evidence, no excessive burden of proof on MasterCard. Develop that point in a moment. But at paragraph 695, you have the paragraph on which Lord Reid commented yesterday about the general proposition in the last two sentences at the top of page 7085. And as you'll see in a moment, the schemes and the banks appealed to the General Court, and they complained that the Commission's demand for empirical evidence placed an excessive burden on them, and you will see that the General Court gave them a firm negative response. At footnote 840 on page 785, you'll see that the footnote records that an increase in card usage per se may not be a good thing for consumers, including the merchants. Ultimately, it may profit only the banks and the schemes. And this is why you need to have convincing analysis with facts.
Can I just ask, when we come to deal with this, evidently an issue will be how general the terms are in which we deal with it. And one can see the Commission here are starting from a general proposition that there needs to be a balancing done, and balancing obviously requires some idea of the magnitude of the quantities on either side. They then go into the particular details of a particular market and a particular type of restriction that we're dealing with in these cases. And they explain why, in their view, in order to do the balancing exercise here, you have to have quantification of this claimed benefit, that claimed benefit, and so forth, in order to be able to say whether or not, doing the balancing, it outweighs the costs that this system imposes. Now, I'm just wondering to what extent the sort of paragraph we're just looking at, 695,
Yes.
should be read as being as reflecting this particular context, or to what extent it should be taken as having a more general application.
Yes.
You see the point. I mean,
Yes,
it
I do.
affects
No, I
how
do
widely
I do
we should
entirely
deal.
know. And in my submissions, I seek to address it at both levels. I recognise that the proposition that we're confronted with in the appeal is that the Court of Appeal went wrong by proposing that factual evidence was needed in these cases. That's how the Court of Appeal went wrong. And I say the first way to address that is indeed at the level of a general appreciation of the treaty provision, just as your Lordship says. But then if one goes beyond that to the specific type of case that you have before the Court of Appeal, you also see, certainly from this document, that the European Commission and later the Courts on Appeal refer in this context to there being a need for fact. So I read 695, I had read that here in the last two sentences as largely dealing with the general point, as your Lordship mentioned yesterday, but there's a great deal of material here, and perhaps that is also meant to reflect the same point, which deals with the specific context of these cases, and says that in a case of this kind, you would expect there to be factual evidence produced by a party under Article 101, Paragraph 3.
Yes, so it might be said that the way in which the Court of Appeal dealt with it, they rather lumped together the question of the quality of the evidence, as it were, how cogent it was, and the question of the nature of the evidence, whether it was theoretical or based on empirical inquiry. And they also placed together the general guidance given by the Commission as to how Article 101 is to operate, and the specifics of the decision in the MasterCard case.
Yes. So far as lumping together is concerned, I do accept and embrace the point that the Court of Appeal recognised that the standard of proof was the ordinary civil standard, but that you would expect to look for cogency to show that the standard was met because of the nature of the case, and that it is related but separate. They also appreciated that factual evidence was required. So they did regard both of those two things as important, it is true. In that sense, they are both present in the judgment, but I submit that there is no error in any of that. So far as concerns the general guidance and the facts of these case, I seek to say that the two considerations are convergent, that so far as the general position under the law is concerned, one needs to have a factual foundation in the evidence, and that in these particular sorts of cases, one would also expect there to be factual evidence produced, so that there's no need to regard there as being any tension between those two by treating them together.
I mean, the need for cogent evidence might be said to be a general requirement. In the guidelines indicate that the starting point for 101.3 is that you have a prima facie breach of 101.1.
Yes.
And therefore it's already been established that there are likely to be anti-competitive consequences. And against that background, it's not altogether surprising if it has to be, if the alleged benefits have to be established by convincing evidence.
Yes, and that is exactly, almost in those words, what the European Commission said in paragraph 55 of its guidelines in the sentences I took you to before on standard of proof. Absolutely.
But the guidelines themselves, I mean, correct me if I'm wrong, but I don't think they go into the question of the nature of the evidence. But one does see that discussed in the Commission MasterCard decision, and there it might be said that context is playing more of a role.
Well, my Lord, in the interest of time, I won't go back to those now, but I will say that those guidelines, if you have the MasterCard decision open in front of you, if we go back to page 7079, remind you that on page, paragraph 672, and indeed 671, the foot of the preceding page, the Commission there in its decision is essentially quoting from the general guidelines, referring to the things that have to be substantiated. And you'll see from Romans 1 to 4 in 672 that these essentially, implicitly, do bring in the need for some factual basis to be shown. My Lord,
Yes, well, I mean, does it really, I mean, so far as 671 and 672 are concerned, does it really come to no more really than saying that it's inherent in the nature of a balancing exercise that you have to be able to have some idea of the quantities on either side of the balance?
Absolutely, my Lord. That is right, and we agree with it. The starting point, the source for this proposition is the treaty provision itself and the classic case law on what it involves, beginning with Colston and Grundig in 1966. It says that there's a balancing exercise and that a party wanting to take advantage of that provision has to show offsetting benefits defined in the particular way.
All I'm hesitating over is the proposition that in every conceivable situation where Article 101 applies, it is impossible to assess the relative magnitude of the inefficiencies, if you like, versus the efficiencies without carrying out an empirical study rather than arriving at a result through the application of economic theory.
I understand, my Lord. As a matter of generality, one struggles to think of a case where that might apply. I've shown you the way in which the European courts have referred to this in their general exposition, GlaxoSmithKline and the MasterCard case, where it's implicitly assumed, and they use the wording of factual arguments and evidence as a general matter, which does give some comfort. My Lord, to conclude on this, if we go to page 7092, there will be two further references. You saw some of this yesterday. The conclusion of the Commission on this first condition begins at paragraph 729, and at 730 on page 7092, down to paragraph 732, the Commission refers here to why, particularly in the circumstances of this case concerning MIFs, you must expect there to be factual evidence in order to prove your case. And I'd invite you to read in paragraph 730 from 3 lines down, there's no presumption that MIFs in general enhance the efficiency of card schemes, just as there's no presumption that they don't fulfil the conditions of 81.3 of the treaty and are therefore illegal. A MIF may be used by banks to achieve efficiencies as well as to extract rents. The Commission's conclusion on the efficiencies will depend on the concrete evidence brought forward by the parties. So in this particular context, that is what you need. And finally, my Lord, before leaving this document, 2 further references which you have not yet seen. If you go forward to 7095, you'll see paragraph 741. And in that paragraph, very clearly about halfway down, 5 lines down, there's a reference to the importance of the issuer pass-through point that I mentioned a moment ago. The need to look at the economics of the issuing bank's operations. MasterCard's issuing banks, they say, about 4 lines down, are also not obliged under the network rules to use interchange proceeds from MasterCard's MIF in a particular manner, and it remained unclear to what extent MasterCard's issuers indeed pass on the fee proceeds to their customers. It hadn't been properly dealt with. And at 742, they make the point there, while merchants may benefit through enhanced network effects from the issuing side, the expansion effects referred to by the scheme in this case, it doesn't necessarily offset their losses which result from paying the inflated merchant fees. So if I may go from this, the administrative agency's document, to the General Court of Appeal, that is in Authorities 2, at tab 24. At page 946, I'll need to pick up the pace slightly. On the point that had been raised by Miss Rose, about the economics of the card issuing bank's operations, you'll see from 106 down to 109, without reading it in extenso, that at 106, the court says that you have to examine the question in the wider context of the resources and economic advantages which the banks derive from their card issuing business. And then at 107, they make the point that for the credit card operations, the banks get significant revenues from various directions. 108, they make a point to similar effect in relation to the debit cards. And finally, you have 109. It must be observed that the existence of such revenues and benefits makes it unlikely that without a MIF, an appreciable proportion of banks would cease or significantly reduce their MasterCard card issuing business, or would change the terms of issue to such an extent as to be likely to result in holders of those cards favouring other forms of payment or turning to cards issued under three-party schemes, which might affect the viability of the MasterCard system. So there they deal with that point of the issuing bank's economics. And then go forward to 963. Paragraph 222 at the top of the page. They make a point there that an increase in the number of cards in circulation, in other words, the stimulation which the banks are seeking to achieve, doesn't necessarily work to the advantage of the merchants. It may indeed mean that the merchants are even more greatly at the mercy of the banks. It says it increases the applicants, the bank's market power. It's reasonable to conclude that the risk of adverse effects on merchants' custom, of refusal to accept that method of payment, or of discrimination in that respect, is higher the greater of number of cards in circulation. It's just a statement of how an increase in the circulation of these cards is not necessarily, on the facts, going to work to the advantage of the customers. And the final part of this, which I will take you to, is on page 964 over the page, 232 and 233 at the bottom, the last two paragraphs. Here, the court is addressing the complaint which was made on appeal that the Commission is insisting on an unreasonable degree of precision. Too high a burden is placed on them if they have to show factual evidence. And if you read 232 and 233, you'll see that the court rejects that firmly. 232, so far as concerns the allegation relating to the lack of data capable of meeting the standard demanded by the Commission, even if that were established, it doesn't mean the burden of proof is eased or even reversed, as the applicants seem to suggest. It must be observed that such a difficulty might be regarded as having been resulted from the arguments developed by the applicants during the administrative procedure. In other words, if that's the case you're making, that something which is likely, you would postulate, to harm competition, in fact results in benefits, then you must show that. So to summarise, the Commission decision and the General Court judgment show the importance of factual evidence, not only in the 1013 balancing exercise as a general proposition, but specifically in the context of this sort of case. And that tells against the scheme's arguments before this court that the Court of Appeal erred in law by finding that factual evidence is required to carry out the balancing exercise. Now, I move from the guidance provided by the European institutions that factual evidence is needed in this sort of case to show you how this is confirmed by the particular manner in which both of the schemes, the appellants here, have put their case for exemption in this litigation.
But before you leave the general approach, are you going to say anything about the merchant indifference test?
Yes.
Oh, yeah, fine.
Well, if I have time.
Yeah.
That's on my critical path.
And I'm sorry, I think you told us that the CJAU also rejected the complaint about precision of evidence. Is that right? If so, not now, but can we be given the reference? It'll just help us later on.
Yes, I must confess if I said that,
Oh,
I
perhaps
may
not.
I may have misspoken.
Okay,
I will
so
check
it stops with the general
I
court, does it?
believe it does, but
All right.
I will check. I will
Thank you.
check that. So I turn then to the case which has been made by the schemes in this litigation. And you will see that it reflects the line of argument which MasterCard was advancing in the European proceedings. If you take first MasterCard, the case which they set out to prove was outlined by Mr. Justice Popplewell at paragraph 310 of his judgment. If I may invite you to go to his judgment in Core Volume 2, you should have that at page 5716 for the relevant point. (5717). Under the heading at the bottom of page 5716, benefits caused by the myth, question mark, at paragraph 310, the judge records MasterCard's case, the way that they put it. And I focus on subparagraphs 3 and 4 at the top of page 5717. Higher myths allow issuers, they're not required, to offer lower costs or higher benefits to their cardholders. In particular, MIF revenues allow issuers to avoid annual card fees, offer lower rates of interest, and fund cardholder rewards, which incentivize cardholders to hold cards and use cards more frequently. Higher MIFs therefore encourage greater use of payment cards, and at 4, greater use of the cards increases the volume of benefits that the merchants get. That was essentially the case that they made. And the case sought to be proved by Visa in this litigation is essentially the same, with one refinement. And for your note, that's, or perhaps we should look at that, that's in Mr. Justice Phillips' second judgment, page Core Volume 2. I have the internal numbering, paragraph 10, 5815 is the page. You'll see there that Mr. Justice Phillips records Visa's case as to the mechanism by which its MIFs contribute to increased net efficiencies is as follows. And there it's set out, but you'll see at letter D a variation that Miss Rose has referred to in this court, particularly in relation to contactless cards. Certain of the benefits provided to cardholders to encourage usage also increase the efficiencies derived from transactions which would in any event have been paid for by card, the always card transactions. Now, I return to Mr. Justice Popplewell in his judgment at page 5717, because the court will need to be aware of this feature of his reasoning. If the factors set out in paragraph 310 amount to potential benefits to the merchants and cardholders from these MIFs, the harm which is suffered by the merchants is nonetheless plain and obvious. They're worse off by the amount of the MIF that they pay. And one of the key reasons why the Court of Appeal overruled Mr. Justice Popplewell on this part of the case is that in his analysis which followed, it's extensive, the judge fatally assumes that there can never be a net detriment from the charging of interchange fees. And you see that if you go back to the Court of Appeal judgment in the same volume, various places, but if you look at page 5260, they make that point in their paragraph 248, where they talk about two related errors in Mr. Justice Popplewell's reasoning. The first is that the judge simply accepted MasterCard's case that the default MIFs led to increased card usage, which in turn always conferred benefits on the merchants. So that was why this judge took a wrong turn. All Mr. Justice Popplewell was concerned to do in his judgment from that point was to quantify the amount of the undoubted net benefits coming from interchange fees. And in very simple terms, he worked out a figure which he said was the financial value to merchants if their customers use cards. He then applied a rough and ready discount to that figure to reflect the fact that the issuing banks keep some of that money for themselves as profit. And the outcome of his approach would always show that there was a net benefit from the MIF, simply because of the mistaken way he set that up. The Court of Appeal pointed out that by doing so, the judge effectively failed to carry out a proper balancing exercise to establish whether the benefits of these MIFs outweigh the harm. And the relevant paragraph in the Court of Appeal judgment that you should see on that is at the bottom of page 5259, paragraph 246. You'll see there that they say that Mr. Justice Popplewell, of perhaps even more significance in the first two matters, he effectively failed to carry out the balancing exercise to establish that overall the restriction, the MIF, provided appreciable overall objective advantages of such a character as to compensate for the disadvantages. And over the page at the top, page 5260, he refers to these two relevant points. The disadvantages are twofold. First, the extent to which the MIF income isn't passed through to the cardholders, but simply retained. That's the issuer pass-through point. Perhaps the Court of Appeal shouldn't have referred to that as a disadvantage to the cardholders, but they're talking about issuer card-through being the first big point. And second, so far as the merchants are concerned, the extent to which they bear a major burden from paying the MIFs on card transactions, which would always have been card transactions using the scheme's cards, irrespective of the MIF. Those are the two key factual matters which do need inevitably to be considered. So to summarise, in this litigation before this court, the nature of the case which has been put by both Visa and MasterCard under Article 101, third paragraph, involves a need for factual evidence. And I say this, what is more, both MasterCard and Visa have entirely accepted that this is the case in their approach to the litigation thus far. If you go to the Court of Appeal's judgment, again, we start with MasterCard's argument about Article 101, paragraph 3, and please look at page 5258 at letter E, halfway down. There's a section which is headed MasterCard's arguments on Article 101.3. Paragraphs 238 to 240 are relevant. At 238, it's recorded that MasterCard's counsel submitted that the judge had adopted the correct approach, taking this merchant indifference test as a benchmark or starting point, and then considering the evidence which supported the case for exemption. And I draw your attention to the fact that in footnote 11 to our written case, he described that as evidence in relation to each of the relevant 101.3 conditions. Then at 239, you'll see that MasterCard claimed to have produced detailed evidence, 5 lines down, on the extent of issuer pass-through, although not from issuers themselves. And then at 240, Always Card, MasterCard submits that the Always Card issue would not even arise unless the market was regarded as mature. It wasn't therefore an irrelevant consideration. They are accepting that this too is a matter for evidence. Finally, if you go back to page 5227 and you look at paragraph 88 of the Court of Appeal's judgment, there the Court of Appeal referred to the causal link point. To what extent does the receipt of this money lead to the banks taking these steps and it having an impact. And you'll see that they say 5 lines down, just above letter E, that this was not really in issue at trial, that both these stages had to be established. And these are all factual matters. As respects Visa's position on the appropriateness of proving their case by means of factual evidence, in the interest of time, may I perhaps direct you briefly to look at our written case in Core Volume 1, page 5111 in tab 20. This is 88B on page 5111. And 5 lines down, Mr. Justice Phillips' judgment records in particular, paragraph 36, Visa contends that its case is supported by evidence which proves that its UK MIFs do contribute to demonstrable and measurable benefits. And then there's a reference to the statement supporting that made by Visa's counsel in the Court of Appeal. And so the case made by both of these schemes does depend, and hitherto has always been accepted to depend, on factual evidence. And finally, there are 2 paragraphs in Mr. Justice Phillips' second judgment which are particularly useful in illustrating the importance of what are admitted relevant factors. So that is Mr. Justice Phillips' second judgment. If you go in it in bundle 2, Core Volume 2 to page 5822, he said at paragraph 41, towards the foot of that page, and this is part of his reasoning as opposed to the error that the Court of Appeal discerned in his judgment, that he hadn't got sufficient facts to have reached the conclusions he did. He said it would seem logical that the expenditure, that's on the cardholders.
Sorry, the paragraph.
41.
Thank you.
He said it would seem logical that the expenditure, that's by the banks on cardholders, would be less than the additional revenue anticipated, the basic incentive being to profit from increased MIF revenue. The interrelationship between existing interchange fee revenue expenditure and anticipated increased interchange fee revenue is unexplained and opaque at best. Now, Visa succeeded in the Court of Appeal in saying that he was wrong to have said that as a matter of fact, and it's gone back to be remitted. But the issue which needed to be considered, he was right about. Those things do need to be looked into. And similarly, at paragraph 49 on the facing page, he's talking about the causal issue, the link between the receipt of this money and the supposed conferring of the benefits. He said, while empirical evidence is needed to demonstrate that a real link in fact exists, there was certain evidence above which, in favour of the merchant, which seems to me to be proof of the fact there is no such link. It's consistent with the fact the card market in the UK is regarded as mature, with the result that a large percentage of card transactions are always card, and the percentage of card transactions which can be incentivized to switch from cash is relatively small. Then he made a comment about contactless. It may be that the recent success of contactless cards has led to a large percentage of transactions switching from cash. But this is a function of the speed and convenience of the new product. It's not necessarily anything to do with the MIF. It's a factual question, not something that one should assume. Now, in view of the matters I've covered, the next point is to address directly the paragraphs of the Court of Appeal decision that Mr. Hoskins yesterday said to you were flawed, owing to an insistence on empirical evidence in these cases, and on the view that any evidence from schemes had to be cogent, which he regarded as an enhanced standard foreign to English law. here, there was a range of paragraphs beginning at paragraph 242 of the Court of Appeal judgment, which you find at the foot of page 5258. Now, I'm not going to go through, in the interest of time, I'm not going to go through each of these in turn, but I will make the point in relation to a few of them, and then the same applies for all of them, that although the court refers to the existence of some expert evidence on the fact of, for example, some pass-through from the banks to the cardholders, they make the point, the Court of Appeal, repeatedly, it is a theme, that what is lacking is evidence of the extent to which this happens to enable a balancing exercise to be done. So in 242, for example, the first of these at the foot of page 5258, in identifying the flaws in Mr. Justice Popplewell's approach, they say, first, in considering the first critical stage in the causation analysis, namely whether the issuers were incentivized to increase usage, and please underline the words, to a greater extent than they would have been anyway, the judge has noted towards the end of his analysis the absence of any factual evidence from the issuers, but he paid insufficient regard to that absence of evidence. This may have been because it was accepted by the claimant's expert that there would have been some pass-through. So there's the factual economic theory point of MIF income, a matter to which we return below. We consider, however, that the judge doesn't address at all the question whether the issues would have sought to incentivize card usage from other sources of income anyway, irrespective of the MIFs. Then in the following paragraph, they refer to two recitals, one of which I took you to expressly from the Commission decision about the need to look at the economics of the issuer's card operations more broadly. And they said that that shows the significance of the need to look at this question of the extent to which there is a causal relationship. And at 244, this was a matter on which only factual evidence from the issuers could have remedied an obvious gap in MasterCard's evidence. Throughout this, the same point applies for all of the paragraphs that you were taken to. There's a reference to an expert having given some evidence of theory about a fact, and the court then saying the extent of this has not been properly investigated. By the way, one diversion that is necessary to make at this point, if you would please keep your finger in the Court of Appeal judgment, is to go forward to that reference from Mr. Justice Popplewell, which I read a moment ago in paragraph 242, which was paragraph 408 of Mr. Justice Popplewell's judgment. That is at page 5741 of this bundle. 5741, we'll see that we're now in Mr. Justice Popplewell's decision. Under the heading Issuer Profits on that page, at 408, to which the Court of Appeal refers, he said, that judge, I have not had substantial evidence of issuer profits or issuer finances which might assist on this question. This went to issuer pass-through. Neither side called any witness with substantial contemporaneous experience as an issuer. The documentary evidence was exiguous. So it's this lack which the Court of Appeal, by referring across to 408, is pointing up. 245, at the foot of this page, back in the Court of Appeal, page 5259, you will see is referring to the extent of a particular effect being lacking in evidence. Secondly, the judge hardly addressed the second critical stage of the causation analysis, namely the extent to which card usage actually increased. And further down refers to the expectation, 4 lines up from the bottom of that paragraph, of some factual or empirical evidence from those issues as to the extent to which pass-through was having the desired effect. All of the paragraphs that Mr. Hoskins referred to are essentially to the same effect. One point I should refer you to is that in his description of what he was attacking, Mr. Hoskins did not attack paragraph 250 on page 5260, and that was the finding, as you see from the first sentence. The second error in the judge's reasoning was his rejection of the always card point, because that judge, unlike Mr. Justice Phillips, did not attribute importance to that empirical factor. And the incompatibility of what that commercial court judge had done in relation to issue of pass-through was in fact specifically commented on by the other judge, Mr. Justice Phillips, in terms that we adopt in this context. If you go forward in the same bundle to page 5826, and you look there at the top paragraph, paragraph 51, you see that judge, Mr. Justice Phillips, now commenting on the judgment which has already been produced of Mr. Justice Popplewell. And 7 or 8 lines down, he criticises the approach taken. He says, for example, in reaching his conclusion as to the exempt levels of MasterCard MIFs, Mr. Justice Popplewell was invited to make the broadest of assumptions as to the level of MIF passed through to cardholders by issuers, based on equally broad estimates of issuers' overall profit margins and various assumptions. Assuming pass-through of 75% for credit cards, 40% for debit cards, he duly discounted his assessment of merchant benefits by 25% for credit cards and 60% for debit cards. And then this: I have no confidence that that type of exercise would produce anything approximating a true valuation of the allegedly pro-competitive effects of MIFs across the whole of the UK in the real economy. It would be a remarkably unsatisfactory and surprising way of assessing whether an agreement at a particular level is unlawful under a statute. In my judgment, neither EU nor UK competition law anticipates such open-textured assessment of whether an agreement is lawful. The strictures set out in the Article 1013 guidelines as the approach to the proof of efficiencies speak to a far more rigorous approach. So to summarise, there's nothing wrong in principle with the Court of Appeal's reversal of Mr. Justice Popplewell on the grounds that have been advanced to this court. I now turn to the argument in MasterCard's written case, and in a more muted fashion orally, that in carrying out this balancing exercise, there's no need for a court to consider certain inconvenient facts of issuer pass-through, or the always card issues, or the causal role of a MIF in prompting increased card use. This is the point of the submission that a court can apply a methodology which dispenses with all of it. In response, the propositions that we rely on are these. First, the whole line of argument is an illegitimate expansion of the ground of appeal on which permission was granted. You were given a point of law on whether the court had erred in relation to the standard of proof that the schemes were required to meet because it unduly constrains domestic law. And now you have a claim that EU law, in fact, dictates an answer by reference to a specific economic model. There's an irony in that, given the ground of appeal, but it opens up more precisely, and despite what Mr. Hoskins said yesterday, a large new topic outside the scope of permission, which cannot be properly addressed within the confines of this hearing. Now, having said that, second, the reliance on the theory of this test to avoid grappling with the issues raised by their case under 1013 is in any event misconceived. And that is because this test is a tool which the Commission and the European legislature have used as a shortcut or proxy in lieu of a balancing exercise with the aim of achieving a quick win for consumers. The theory of this test does not even purport to avoid the need to understand issuer pass-through or always card issues for an appropriate balancing exercise to happen. So now I address it directly. The principle behind this merchant indifference test is that on its own, it's designed to do something different from showing that the scheme's MIFs are indispensable for bringing benefits to consumers. What they are is a safeguard. They guard against one aspect of the competition concerns arising from MIFs, the concern that the merchants are vulnerable to being exploited by the banks because they're typically in a poor position to resist consumers who want them to accept cards for their goods or services in case they lose businesses to rivals. That means that merchants become more willing to accept very high level of interchange fees, even when they're much more expensive for them than other methods of payment. And what the MIT, merchant indifference test, is designed to do is to ensure that the collective interchange fees don't rise up to a level which means that the cards are more expensive than other ways of paying. But the fact that the MIF passes that hurdle doesn't tell you that the private tax brings benefits to consumers, merchants and cardholders together, under the first condition of Article 1013, compared with there being no such collective agreement. And indeed, the authors of the test themselves explicitly recognise this, that a MIF which satisfies that level may make consumers worse off unless you make a critical assumption, which is that the banks don't take any of the MIF income as profit, any of it, but recycle the lot to cardholders. And if I may, I will show you this by going to the same article that Mr. Hoskins took you to in Appendix 1D. And you'll need to go to page 7303. Which is the beginning of the article. And then in it, turn the page to 7304. I'll show you a few references here. So this is a page, part of which was read, but not this part. In the second paragraph, third paragraph in the middle of that page, towards the end, the authors say here, we show, last sentence.
Sorry, I haven't got the pen.
7304.
Yes.
So towards the, about 2/3 of the way down that page, in the paragraph which begins second comma, last sentence, we show that when issuers' margins are constant, the tourist test is an exact test of excessive interchange fees from the point of view of short-term consumer surplus, and yields false positives if the criterion is something else. When issuers' margins are constant means that there is full issuer pass-through, that they're not profiting from this practice. And you see that if you go forward to 7327 in the conclusion section and look at the 4 lines down from the top. When issuer margins are constant, they're not being boosted by profits from this practice, and merchants are homogeneous, the tourist test, their test, is a proper and practical policy tool. And then at the end of that paragraph, a key result of this paper is thus that with constant issuer margins and homogeneous merchants, a regulatory cap based on merchants' avoided costs is legitimate when competition authorities aim at maximising short-term total user surplus, the benefits on the consumer side. So there you see the assumption that is built into this test. Also, contrary to what Mr. Hoskins said yesterday, the theory of this test certainly does take account of always cards. If you go to page 7313,
Just before we do, I'm sorry, I must be being a bit slow. Why does constant issuer margins imply full pass-through?
it's because you're making a certain amount of money without the receipt of this income. And the assumption is that when you get the income, you channel it all back on the cardholder side, and therefore your profits and your profit margin is not boosted by the receipt of the income.
Oh, I see. So you're envisaging the margin being an actual receipts rather than some sort of proportion of the amounts passing through the issuer's hands on card transactions.
Yes, it's essentially their profit margins. Again, I'll need, if in the remaining time, I'll
It might take too long to explain.
Well, that's part of the problem that I referred to at the outset, is exactly this. And I'm going to show you something else, which I fervently hope that your Lordship's not going to ask me too much about. If you go to page 732, 7. Right.
We were there. You were taking us to 7313.
That was, that's right, 7313, thank you. Yes, at the top of the page, let us explore that equation with 12 alongside it.
Right.
The only way in which I ask this court to explore that equation is as follows.
Yes.
Before this hearing, we supplied the court with a table, and I don't know if you have that loose. Do you have a table which refers to how this all works? And I'm going to show you only one line in that table. This was a table produced by Mr. Dryden, the AAM expert at first instance, showing
I think
how
there are
this...
some more copies coming, Mr. Turner.
I see. It's what you're about to see is a document that was produced by the expert which shows how this part of the test works, and that it depends on that calculation, the extent to which the market is mature or always card. And you'll see towards the bottom of it the explanation given. The expert says in the first column, Neil Dryden, the number of switching transactions must be sufficiently large relative to the number of always card transactions. That's as part of the benefit that is calculated. There is then, in the third column, the same equation that we have just been looking at from the article. And the explanation in the final column, last sentence, if the number of switching transactions is sufficiently low compared to the number of always card transactions, the total user surplus maximizing level of this fee becomes zero or negative.
Switching transactions are ones where the person is switching from another form of payment to the use of a card.
That's right, yes. As opposed to...
I mean, it's intuitively understandable, I've thought. The MIT depends on the merchant incurring a cost if people pay with cash. If they're not going to switch to cash, therefore the merchant hasn't got the risk of that extra cost, then the benefit of using a card, because people will be using a card anyway, can't be justified by the myth.
Exactly, that is the intuitive point. The benefit doesn't arise, claimed by the schemes, in that sort of case. And so the point...
I'm sorry, because I don't want there to be any misunderstanding about this, and I do think Mr. Turner has made it clear that's not the position in the visa case. And your Lordships will know that in the visa case, this whole question has been remitted for rehearing to the CAT. Yeah. And I'm anxious that nothing that this court says would foreclose our arguments. But it is an important part of visa's case that there are benefits to merchants on always card transactions because the MIF stimulates technological advances like contactless. So a transaction that would have been made by chip and PIN and it's now made by contactless would always have been made by card, but still results in a benefit to the merchant.
Yes, but that wouldn't be calculated in the MIT, would it?
Well, my lord, it depends what you mean by the MIT. It's still the MIT methodology, but the MIT methodology has been modified from this version. Indeed, Rocher and Tirole have themselves subsequently modified the MIT methodology to include, for example, allowance for credit benefits. So I am anxious at the extent to which my learned friend is getting into the detailed economics of this, which with respect are not before this court, and which haven't been resolved in Visa's case.
I only have a few more minutes, so I must...
Can I just make it clear that, again, this is not settled as between us and AM. This was very hotly disputed and remains so.
I think we need to get on. I can't see the court going into the details of these economic formulae in our judgment.
Not at all. What I am doing is addressing an argument that was put to you yesterday that this is no part of the MIT theory, and I've shown you that that is incorrect. Now, the authors are aware that the MIT level doesn't provide by itself a sufficient framework for assessing the Article 1013 conditions. You have to have some framework which admits of real-life facts that the banks will take some degree of profit and that there will be an extent to which, potentially a very large extent to which, consumers are always using these cards anyway. But the schemes nonetheless are saying that this is a test that you should consider to be appropriate in this context because it has been applied by the Commission in recent cases, and they refer to these commitments decisions.
Well, I think Mr. Hoskin's argument was essentially that the Commission's use of the MIT test illustrated how it wasn't always necessary to have an empirical data-based approach, but an economic theory-based approach could be sufficient. I think that was essentially what...
It was an evidential point, absolutely.
Yes, absolutely.
My Lord, I agree. The response to that point is that the Commission has not said, and did not say in those decisions, that you did not need for a proper 1013 balancing exercise to consider those conditions. The commitments decisions are different, and the undertakings which were given by MasterCard. So if I may refer to these, if you have Appendix 1D, start with one of the documents referred to by MasterCard that you have not yet seen, and that is at page 7160. MasterCard eventually compromises its dispute with the Commission and gives undertakings. If you look at page 7165, you see a paragraph important for present purposes. 7165, will any MIF that satisfies the tourist test, that's the MIT, be automatically...
Where on 7165?
7165, towards the bottom in bold type.
It's the
Yes,
heading.
thank
yes.
you, the heading, thank you.
Yes. Will any MIF that satisfies the tourist test be automatically compliant with Article, what's now 1013 of the treaty? The tourist test provides a reasonable benchmark for assessing a MIF level that generates benefits to merchants and final consumers. And then it explains that it's cutting out one of the detriments from the application of the MIF, the so-called business stealing effects. But the last sentence says the general applicability of the tourist test for the purposes of 81.3 depend on the specifics of the market at hand. Some non-exhaustive cautionary examples are listed below. And if you go over the page, there are 4 non-exhaustive examples listed, and you will see the second of those is that where a payment card would reach universal usage in the market, even without the MIF, essentially an instance of always card, the need to promote the issuing of such a card in terms of network effects would vanish. It's similar to what my Lord Hodge was saying.
Making. Yes.
The third point is about the need for some channel through which these fees are actually producing effects, and in relation to, for example, debit cards, one's aware that one doesn't tend to receive rewards or lower costs for the use of the card there. So any sort of mechanism is much more obscure than it is with credit cards. Now, this isn't merely historic. In 2015, so very recently, the Commission, in its cost of cash survey, giving a more up-to-date position, essentially says the same thing, and I'll simply give you the reference. This is the applicant's additional documents bundle at tab 15, at paragraph 72, page 7605. So essentially, almost verbatim, the same language has become part of the Commission's approach. And the only document then which I shall take you to in the applicant's additional documents is the 2019 commitments decision, which you find at page 7522. Most recent one. The others will spend more time on this in view of the limitations, but you'll see that they say there in relation to what is a commitments decision, at paragraph 71 on page 7538, when analysing MIF levels, regard should be had to the merchant indifference test, a methodology originally developed in economic literature. It is a benchmark or proxy for assessing compliance, but that does not mean it is a way of performing a proper analysis. It is a shortcut, and it ensures that merchants benefit from card acceptance. If you turn over to page 80, paragraph 88 on page 7541, commitments deal with the preliminary competition concerns identified by the Commission in an efficient manner. It's quick, it gets a win, as they provide a direct and tangible benefit to the merchants and ultimately consumers in the form of MIFs that are substantially lower than the current levels. So what the Commission is doing by this beneficial mechanism of commitments decisions is achieving a quick win. And recital 108 on page 7544, without prejudice to Article 9.2 of Regulation 1, which is the ability to make a formal infringement decision going through all of the relevant steps, they bring the proceedings to an end. So in conclusion, the reliance on this test as laying down the appropriate approach to assessing compliance with the 1013 conditions is misplaced. Final submission, if I may then, and then I'll just take stock of one or two notes. Yesterday, Mr. Hoskins said that not only did MasterCard want guidance about the right test from this court on the standard of proof and the type of evidence that might satisfy the standard, we have no complaint about that, but he suggested that they were seeking that the whole of the Court of Appeal's analysis of Article 101, third paragraph, should be set aside. That's an extreme conclusion to draw, and it does not follow from the points which he advanced, even if he was right about them, which he isn't. You take the standard of proof, the high watermark of the attack on that issue was back in the Court of Appeal's judgment at paragraph 80 that we went to. And I've explained that they're misreading what the Court of Appeal said. But if I'm wrong, all that means is that paragraph 80 is wrongly stated. Mr. Hoskins hasn't shown that that supposed error determines any of the Court of Appeal's substantive analysis. And then if you take the point on factual evidence, nowhere does the Court of Appeal rule out economic theory evidence. It does say that factual evidence is required in this case, but MasterCard no longer says otherwise. They actually emphasise that they did have certain empirical evidence from their cost of card merchant survey. So the argument reduces to something very specific, which is what particular matters in this case is it that a court needs empirical evidence on. But on that issue, that detailed point, Mr. Hoskin said he's not asking this court to endorse the theory. And yet it is that theory and that theory alone on which he is relying for the proposition that no empirical evidence is necessary on the extent of pass-through or on the extent to which there's an always card effect. My Lords, finally, I've been handed a note concerning Lord Sale's question about what the Court of Justice said on the standard of proof and evidence. The Advocate General addresses this at paragraphs 136 to 149, I'm told, page 1031 of the bundle, and the Court at 215 to 219 says that this is an inadmissible plea and addresses it in that way at page 1075.
Thank you.
Subject to any questions from the court, those are my submissions.
Well, thank you very much, Mr. Turner. Mr. Brealey.
I'm not sure there's any light relief, but I would like to begin with ground one, the restriction of competition. And on ground one, I'd like to add to Mr. Turner's submissions, but concentrate on the counterfactual, that is the scheme's zero myth argument. I want to concentrate on that, the scheme's zero myth argument. And I'll do three things. First, I'll recap on what the zero myth argument is. Then I will show how the same argument was run and rejected by the CJU and MasterCard. And then third, I'd explain why the Court of Appeal was right to reject the zero myth argument. So I start with the scheme zero myth argument. And on the zero myth argument, there are three core facts relevant to the counterfactual. And these three core facts are accepted by the merchants and the schemes, but in my submissions, the parties draw different legal conclusions from them.
Sorry, Mr. Brealey, I'm having a little difficulty hearing. I think it may be the microphone.
Those won't project your voice. They merely take the recording elsewhere. Yes. You have to speak up.
Okay, I'm sorry. The first core fact is that the myth imposes a minimum price on the merchant service charge. So that's the first core fact. The myth imposes a minimum price on the merchant service charge. And can we go to MasterCard's written case, which is at Core Bundle 1, tab 17. That's MS 4934.
Sorry, whose case?
It's Core Bundle 1,
Yes,
tab
I'm working from a different copy.
4934.
MasterCard.
4934.
MasterCards, thank you. Paragraph?
44.
Thank you.
So this is the first core fact. MasterCard accepts that a myth sets a common floor for the MSC charged by acquirers to merchant. And then the reason is given. The myth sets a common floor for the MSC is explained at paragraph 1210 of the Statement of Facts and Issues. Acquirers pass on all of the myth and the scheme fee to merchants through the MSC, with negotiations between acquirers and merchants in respect of the MSC being limited to the level of the acquirer margin. The first sentence of paragraph 1210 is admitted because that refers to the 90%. But it is important to recognise that this common floor is another way of saying minimum price. That's quite important. Common floor is another way of saying minimum price. And with that in mind, I would just like to recap on what the Commission said in the decision. So we need to go to Appendix 1D, the Commission decision, at 6895, where it says, but go to
MS 7004, and the two paragraphs I want to emphasise are paragraphs 382 and 383. It's the last part of 382, which says the decisive question here is whether overall it is in the common interest of the banks, establishes through the myth a minimum price. So we get their minimum price, and at 383 we see reference to a common minimum price floor merchants must pay. I won't go through all the recitals, but if we go to MS 7100 at the end of this document, 7100, paragraph 759, you see there the remedy. In order to remedy the restriction of competition by MasterCard, these undertakings should be obliged to cease from determining, in effect, a minimum price merchants must pay for accepting MasterCard. And just to nail the point, it is referred to in the article, that's the operative part, at MS 7104, where again, the reference to, in effect, setting a minimum price is clearly a reference to charging something. It's charging an extra fee. Relevant to a point that Ms. Rose made on Monday, I'll come to it. But the reference to minimum price is clearly a reference to a positive charge. It is not a reference to nothing, no charge. And that is the sense used in the decision and the court judgments. So that is the first core fact, minimum price. The second core fact is that in the absence of a collectively imposed fee, it is unlikely that acquirers would be able to charge any extra interchange fee. So in the absence of a collectively imposed fee, it is unlikely that acquirers would be able to charge any extra interchange fee. So if a fee was bilaterally agreed between acquirer and issuer, the merchant would be reluctant to accept the extra fee and would use its negotiation power to play one acquirer off against the other. Now, this fact is reflected in the agreed statement of facts at paragraph 12.9. Yesterday, we saw expert evidence from Mr. Dryden, but to put this agreed fact in its factual context, I would like to go to the first witness statement of Mr. Ashworth. It's been referred to a few times. Mr. Ashworth was a visa witness and was a director of WorldPay, a major acquirer. So if we could maybe just put some of these documents away for the moment, and we'll come back to them. But I would like the court, please, to go to the Respondents bundle. That is the extra bundle of Respondents documents. That is at tab 14. 7849, and for the court's note, this evidence is referred to by Mr. Justice Phillips at MS 5787. So this was referred to by Mr. Justice Phillips, the evidence of Mr. Ashworth. So this is at tab 14. MS page 7849. What he has to say is quite important. Paragraph 12, he just gives, my experience of the UK payment card industry is that interchange fees as part of a four-party systems such as Visa or MasterCard are set multilaterally by scheme operators rather than bilaterally as between issuing and acquiring banks. It is paragraph 16.3 which is the paragraph which is important. So this is at page 7850. This is a world, he's giving evidence of a world without a MIF. If WorldPay were to agree to positive BIFs with issuers, it would be at a significant competitive disadvantage relative to any acquirers who had not entered into such agreements. Anticipating this risk, I believe WorldPay would be reluctant to agree to BIFs. For example, WorldPay was pitching an MSC incorporating a positive BIF to a typical merchant on the basis that such a fee was better for all industry participants because it kept Visa in the marketplace. But another acquirer was offering an MSC based on a zero MIF. I would expect the merchant to choose the lower cost acquirer because merchants tend to focus on their short-term costs. My experience has shown that retailers are always pressing their acquirers to lower their MSCs, even that cost saving is only temporary. I would expect that to be the case, even if that approach jeopardized the continued existence of payments scheme. Accordingly, in my view, it would be near impossible to persuade merchants to accept a higher interchange fee if other acquirers were offering an MSC which did not include a MIF component. I would expect large or small merchants alike to choose the acquirer offering the lower MSC. The last sentence is also very important. Given this commercial reality, I would expect WorldPay to be reluctant to agree a positive interchange fee unless it could be certain that all other acquirers were doing the same. So there are 3 points to emphasize about Mr. Ashworth's evidence. First, the MIF, as a matter of fact, avoids a commercial risk that would place acquirers at, in quotes, a significant competitive disadvantage. That's the first 2 sentences. Second, the MIF gives acquirers commercial certainty. The MIF allows acquirers to charge an interchange fee because they can be, in quotes, certain that other acquirers are doing the same. Certain is in the last sentence of that paragraph 16.3. It does this by preventing merchants pressing, and I emphasize the word pressing, in quotes, it's the third line, their acquirers for a lower cost base, and the lower cost is on the top of that page. Third, Mr. Ashworth's conclusion is obviously that acquirers can only charge an extra interchange fee if they act collectively. They would not be able to charge an extra fee if they acted individually. So that is the second core fact, and I refer to the evidence of Mr. Ashworth in addition to Mr. Driver. I turn to the third core fact, and that is simply this. The third core fact is that in the absence of any interchange fee, collectively imposed or bilaterally accepted, the issuing bank must settle the transaction price. That's the SAP or ex post pricing rule. So in the absence of any interchange fee, collectively imposed or bilaterally accepted, the issuing bank must settle the transaction price. And those are the 3 core facts relevant to the counterfactual of the zero myth argument. Now, the schemes reason that this counterfactual shows that the MIF does not restrict competition. Why? With the collective agreement, there is only competition on the separate acquirer's fee. Without the collective agreement, there is only competition on the separate acquirer's fee. And MasterCard adopts the reasoning of Mr. Justice Phillips in the MasterCard, in the Visa case. And could we please just go back to the Respondent's additional bundle? That is at tab 23. Tab 23 of the Respondent's additional bundle. That's
starts at 8042, but I just pick it up at 8048. 8048. So we've got the core facts, and at paragraph 24 of, this is MasterCard's amended supplemental skeleton for the Court of Appeal, and it was amended in December 2017 in the form of paragraph 24. MasterCard relies on the reasoning and findings to this effect at paragraphs 130 to 161 of the judgment of Mr. Justice Phillips and Sainsbury's in Visa. MasterCard continues to rely on Mr. Justice Phillips' reasoning in its written case, for example, at paragraph 56. So MasterCard relies on the reasoning. By contrast, we rely on the reasoning of the CJEU. And the Court of Appeal, as we have seen at paragraph 146, also agreed with the reasoning of the community courts. That's MS 5239. So I quickly turn to how MasterCard and the banks argued the zero myth point in Luxembourg. Before that, we need to go to Brussels and the MasterCard infringement decision, which the court will know is at Appendix 1D. Starts at 6895. I'm going to see how the Commission and the Court of Justice rejected the zero myth counterfactual. Perhaps in passing, if we can just go to 6907, recital 15, we see there that the British retailers have been complaining about myths since at least 1992. That's recital 15. It's the first sentence of recital 15. The retailers under the British Retail Consortium have been complaining about this for a considerably long time. If one turns over the page and recitals 21, 22, and 26, we see essentially the complaint was made against MasterCard and Visa. The case continued against MasterCard. Visa was given permission to intervene as interested party because the same principles applied to Visa. And Visa made submissions at the oral hearing, which we see from recital 26. So recital 22, we see that Visa was granted leave to intervene because it had a sufficient interest. Same principles apply, and it made written submissions and oral submissions in 2006. So on the zero myth argument, we can start with Visa's submissions. If we go to 6963, this is where the Commission sets out various arguments, and it's recital 219. And we don't need the first part, but I emphasize 219 at the oral hearing. At the oral hearing, Visa's expert also argued that it was hard to imagine how a multilaterally set interchange fee could possibly restrict competition between acquiring banks. Competition among acquirers could not be stronger with at par clearing than with a myth, just as it would be hard to assume that breweries would compete more keenly if one scraps excise taxes. So that is squarely the scheme's zero myth counterfactual. And exactly the same argument was advanced by Ms. Rose on Monday, and I refer, for example, to day 1,
page 49 of the transcript, where she said, "Now, the MIF is not having any effect on competition any more than a payment of VAT would have. Just as everyone has to pay VAT at a set rate doesn't affect competition because everyone's playing on a level playing field. So in my submission, there's no effect on competition anywhere in this process." So this reference to an excise tax or VAT is still being argued today as it was in 2006. So the Commission rejects this zero myth argument. We just need to go to recital 410 at 7011. 7011. I do this for completeness. Mr. Turner referred to it yesterday. But recital 410 is where the Commission articulates why the MIF restricts competition. And in the middle of recital 410, we see the Commission saying prices set by acquiring banks would be lower in the absence of this rule and in the presence of a rule that prohibits ex post pricing. The MIF therefore creates an artificial cost base. Now that is wholly consistent with the evidence of Mr. Ashworth we have just seen, creating an artificial cost base. But the counterfactual is the same. So where do we see this argument rejected, the zero myth? If we go to 7022, again, we've seen these. I'll just do it for completeness and then I'll make some submissions. 7022 at the top, the section 73215, this is where the Commission assesses the various arguments that are being put to it. The Commission's assessment of MasterCard's argument why its MIF would not restrict competition between acquiring banks. So what follows is the Commission rejecting the arguments. Then we go to 7025. We've seen this section before. This is under subsection F. MIF not a restriction because effect would be like excise tax. And paragraphs 455 to 460 effectively endorse the MIF being a restriction of competition and confirm the MIF being and rejecting the zero myth argument. Now the court has been taken to these recitals and I would like to make 3 points that arise from these recitals. The first point is that this section is clearly concerned with the zero myth argument, as the court can see from footnote 515. That is a reference to Visa's expert again, it could not be stronger at par clearing than with a MIF. That is exactly the argument that is being run today and was run before the Court of Appeal and before Mr. Justice Phillips. The second point is the competitive harm of the MIF is that it gives acquirers certainty, again consistent with Mr. Ashworth, and we see the reference to uncertainty, certainty at the end of paragraph 458, where eliminates an element of uncertainty. That's on the top of page 7026. And we see the reference to certainty, uncertainty in the middle of paragraph 460. Competitive harm of the MIF is that it gives acquirers certainty and takes away merchant pressure. And the third point I'd like to emphasize is that this assessment is not dependent on any finding that bilateral agreements would come into existence. Mr. Turner has dealt with this. The Commission will follow me and can speak for itself. And we have dealt with this issue at paragraph 118 of our written case. But I would also, just for completeness, like to refer the court to what the Court of Appeal said at paragraphs 169 to 70 of its judgment. So I think we can put the decision away and just go to the Court of Appeal's judgment at 4 volume 2. That's MS 5244. This is on the bilateral issue. It's paragraph 170 that I particularly pray in aid. This is on the bilateral issue, where the Court of Appeal says there is no inherent difference between the Commission's conclusion that there might be bilateral agreements for a time ending up in no interchange fees and the position where there are just no MIFs without any bilaterals being agreed. And we say that is an eminently sensible approach. Miss Rose said it was wrong, but didn't really say why. But it is an endorsement of the merchant's argument, which one sees at paragraph 121, and that's at 5234. So that paragraph 121, 5234, the merchant submitted that the CJU, so this is after we said there was no distinction about bilaterals, but the merchant submitted that CJU's decision could not be distinguished on the basis of any finding of fact that there would have been bilateral negotiations, the counterfactual. This is not what the Commission was saying at paragraph 460, and the Commission, I think, would endorse this. It was merely saying that the realistic outcome in the counterfactual was no interchange fees. It is irrelevant whether the no interchange fee outcome occurs immediately or after an interregnum. So whether it is a realistic possibility next week or you agree it because you know that's what's going to happen should not be a material distinction. So that is how the Commission rejected the zero myth argument. Can I then turn to the General Court, because MasterCard and the banks appealed this zero myth point to the General Court and lost. A document I don't think we've seen yet is the report for the hearing for the General Court. And that is at volume 11 of the authorities bundle. So as the court will know, before any hearing in front of the CJU and the General Court, there's a report for the hearing. And that is at tab 96 of Authorities Bundle 11. And what I would like to emphasise when we will get, it's a bit of a tortuous route, it's not in this document when we get to the General Court, is that it's clearly the zero myth is being rejected on the basis of reasoning, analysis. So if we go to page 10 of this report,
The MS number?
is 4558, 4558.
Thank you.
It's important to see where the zero myth counterfactual is placed. And we see at page 10, there's at the two-thirds of the down, one, the first plea alleging infringement of Article 1011, in that the Commission wrongly concluded that the setting of the myth constituted a restriction of competition. The first limb of the plea alleging errors of assessment in the analysis, in other words, the reasoning of the effects of the myth on competition. And we see the argument that's put forward at paragraph 59 over the page at MS 4559,
where we see the zero myth counterfactual being run. In the second place, as regards the effect of the myth on competition between acquirers, the applicants and several interveners, they are the banks, state that the Commission has not established that the abolition of the myth would raise the level of competition. In essence, the prohibition on ex post pricing would amount to imposing a zero rate myth, which from the point of view of competition would be the same and as transparent as the present myth, the only difference being in its level. Run and rejected in the decision, it was run in the General Court. I'd like now then to go to, we can put the report for the hearing away and go to the General Court, which, as this court knows, is at Primary Authorities Volume 2, tab 24. Starts at MS 921. Tab 24, MS 921. Now, I agree, and we have always argued, paragraphs 142, we'll come on to them in a minute, 142 and 143 are the critical paragraphs, because they reject the zero myth argument. But although it's a rather tortuous route, it's important to see where that argument is placed in the judgment. Because as I say, I want to show the court that this is a legal argument that is being run. We go to MS 941 first, and again I apologise if it's a bit of a tortuous route, but it is important. We'll get to paragraphs 142 and 143 in the end. So 941, this is halfway down, we see substance. We see A, the application for annulment, and then we see the applicants put forward 4 pleas in law in support of the application. So there are 4 pleas in law. First plea in law is infringement of Article 1011, in that the Commission wrongly concluded that the setting of the myth constituted a restriction of competition. 74, this plea is expressed in essence in 2 parts. There are 2 parts, A and B. We are concerned with B, which is at 948. So if we go to MS 948, this is the part of the plea relating to errors of assessment in the analysis of the effects of the myth on competition. The applicants, supported by several interveners, submit that the Commission's analysis of the effects of the myth on competition is incorrect in a number of respects. We then go over the page, if one's looking at the hard copy, to paragraph 129, where you see the heading in bold, the complaints relating to the assessment of competition in the absence of the myth. So at this point, we are now getting to the counterfactual, because we know that the counterfactual is looking at competition in the absence of the restrictive agreement. We see from paragraph 129, the applicants and the banks submit that the Commission failed to fulfil its obligations to assess the competition in question within the actual context in which it would occur in the absence of the myth. Now that is the test for the counterfactual. Essentially, they raise 2 complaints. 130 relates to the first complaint, which is not relevant to us. We then go over the page, we're almost there, to paragraph 135. That's at MS 950. In the second complaint, the applicants and a number of interveners complain that the Commission failed to establish that the elimination of the myth
would raise the level of competition between acquirers. That complaint can be divided into 4 sets of objections. And then 136 we get in the first place, which we can ignore. And then finally we get home at 142 and 143, which is in the second place. In the second place, the applicants submit in essence that the fact that the MIF had an impact on the level of the MSC does not affect competition between acquirers because the MIF applies in the same way to all acquirers and operates as a cost that is common to all of them. Thus, the prohibition of ex post pricing would effectively impose a MIF set at 0, which from a competitive aspect would be equivalent to and just as transparent as the current MIF, the only difference being the level at which it is set. And that 0 MIF counterfactual, the argument that has been running today, is rejected since it, and we've seen this, since it acknowledged that the MIF sets a floor, i.e. a minimum price for the MSC. It necessarily follows that the MIF has effects restrictive of competition. By comparison with an acquiring market operating without them, the MIF limits the pressure which merchants can exert on acquiring banks when negotiating the MSC by reducing the possibility of prices dropping below a certain threshold. So that is the same counterfactual, the same argument that is run time and time again and has been rejected by the General Court. Lastly, before the adjournment, can I go to the CJU, tab 25, MS 979. We know that appeals from the General Court to the CJU are only on points of law, and that is endorsed by the CJU at paragraph 105, MS 1058, which says that the following arguments are questions of law. And there are essentially 2 things to note from this judgment. The first, I'll set them out and then I'll explain them probably more after lunch. There are 2 things to note from the court's judgment. First, the CJEU considered that the ex-post pricing rule, that's the SAP, was less restrictive of competition than the MIF. So it's a positive finding that the SAP, the ex-post pricing rule, is less restrictive of competition than the MIF. Very important for the counterfactual. The second point to note is that the CJU considered that the MIF restricted competition in the acquiring market because it limited the merchant's negotiation power, and in doing that, it expressly rejected the 0 MIF argument. Got time before the adjournment to probably deal with maybe both, but certainly the first aspect is the finding that the SAP is less restrictive of competition than the MIF. If we go to MS 1069, at paragraphs 171 to 173, it's paragraph 172 that I emphasise. It's relying on it's endorsing paragraphs 95 and 96 of the General Court. In 95 and 96 of the judgment under appeal, the General Court correctly considered that the Commission was fully entitled to conclude that, and then it quotes from the General Court, the possibility that some issuing banks might hold up acquirers who are bound by the honour all cards rule could be solved by a network rule that is less restrictive of competition than MasterCard's current solution, that by default, a certain level of interchange fees apply. The alternative solution would be a rule that imposes a prohibition on ex post pricing on the banks in the absence of bilateral agreements between them. The CJU is clearly agreeing here that the SAP is not as restrictive as the MIF.
Therefore, in the absence of a MIF scheme rule, a less restrictive scheme rule would apply, and that gets the merchants home and the commission home on the counterfactual. That is exactly what the counterfactual is designed to ascertain, whether there is a less restrictive rule. And I ask the court to note that this statement is not dependent on the SAP imposing a minimum price, as Miss Rose appeared to submit on Monday. She said that was a distinguishing factor. It is a statement that of the two network rules, the SAP and the MIF, the SAP would be less restrictive of competition. It is true that paragraph 95 of the judgment of the General Court does refer to the fact that the SAP does not set a minimum price, but it is a statement. But as we saw earlier, the reference to minimum price has a distinct meaning. Article 1 of the operative part of the decision, minimum price means charging a positive fee, which is a minimum price. So the distinction is not there. Maybe before I would just go to the other critical, the second aspect, which is at, and then I'll finish, at 1072, MS 1072. Again, we've seen these paragraphs before. The reason I want to go back to this, A, because they're obviously very important, but to highlight one point. So if one looks at paragraph 192, this is meeting, I think, Mr. Hoskins' point, or certainly RBS's contention, that there was not a sufficient analysis of the effect. But at 192, the court says, having properly relied on the counterfactual hypothesis of a system operating on the basis of the prohibition of ex post pricing. So just pausing there, all I'm asking the court to note is the reference to counterfactual hypothesis. And that is a system operating on the basis of the prohibition of ex post pricing, that is the SAP. And the reason I emphasize that is because when we get to the critical paragraph 195, the court says, the appellant can't criticize the General Court for having failed to explain how the hypothesis applied had less restrictive effects. So the hypothesis is the counterfactual. It is the counterfactual hypothesis of a system operating on the basis of the prohibition of ex post pricing. So it's just important to see the connection between hypothesis in 192 and 195. But the real point is the CJAU is rejecting the scheme's zero myth argument. As the Commission rightly points out, the judgment under appeal is not based on the premise that high prices in themselves constitute an infringement. High prices merely arise as a result of the myth which limit the pressure which merchants could exert on acquiring banks, with a resulting reduction in competition between acquirers as regards the amount of the MSC.
Well, if that's a convenient moment, we'll adjourn and resume at 2 o'clock.